Good afternoon, everyone. Thank you for tuning in at the iLaw Lunchtime webinar series, Arbitration and Mediation. We understand that you're very busy, and that's why we've launched this 30-minute series for you to gain some basic knowledge over different legal practice over lunch. Today, we're very pleased to have our Head of Arbitration, Jenny Lau, and our Managing Partner, Mark Culbert, who will be sharing some pointers and things to consider on the arbitration and mediation side with you. We'll also have a Q&A section at the end, which our speakers will try to answer your questions live. And this webinar will be recorded, so just to aware that your name might appear on the Q&A section if you didn't choose to answer anonymously or ask anonymously. And so let's get started. Jenny, you now have the stage to present the slides on the arbitration side.
Thanks, Bonnie. Right, so I'm just going to put my slides up. Everyone can see these. Right, well, thank you for joining us today. I'll be taking you on a flying high-level tour through arbitration in general. We're going to point out some of the key considerations and differences to litigation as we go through. I appreciate that some of you already have quite detailed knowledge of the arbitration process, in which case today will be a bit of a refresher for you, as we're going to look at things at a very basic and entry-level way. I'm going to split talk today into three sections. We're going to look at the arbitration agreement first, then touch very, very briefly and quickly through the process itself, and then look at some of the pros and cons of arbitration and maybe debunk some of those myths we picked up in law school. Just to kick things off, I'm going to start with a bit of history. So arbitration was first formalised in England and Wales when Parliament enacted an arbitration statute in 1698. The statute was drafted by John Locke as an assignment for the Board of Trade. Locke appears that the driver was to put in place a private dispute settlement method that merchants could use with minimum legal entanglement. It seems that Locke had a bit of a problem with the legal profession. He set out in his journal a list of all the things which hindered trade, and you, I'm sure, will be horrified to hear that multitudes of lawyers made it onto the list. So arbitration, it's a private agreement between parties about how they want their dispute to be resolved. You'll sometimes hear it being referred to as a form of private court. The parties end up with a binding decision, which, depending on the seat of arbitration and the local laws in the seat, there will be certain limited opportunities for challenge. I'm going to pick up with the arbitration agreement. First, there are four considerations here. You've got your incorporation and scope, the seat, ad hoc, institutional, and the tribunal. Let's pick up with incorporation and scope. I particularly like this cartoon because I think it really highlights why incorporation and scope is important. The arbitration agreement is one of the most important documents or clauses in your arbitration process, but unfortunately, because it's dealt with at the early stage in the transaction or project, it's often considered a boilerplate clause by the parties, and people rarely spend very much time thinking about it. Of course, by the time you get to the point where you have to rely on your arbitration clause, it's far too late to think about it then. You don't want to be in a position where you're in court arguing about where you should be arguing. There are 2 points here. Make sure your arbitration agreement is clearly incorporated. What does that mean? Well, make sure everybody's agreed, everybody understands what you're agreeing, and that there's evidence of this agreement in the form of a final signed contract. And then consider the scope of your arbitration agreement. What type of disputes do you want it to cover? Is the wording clear? Is there any scope for manoeuvre or any grey areas that you've forgotten to fill out? With a normal transaction that's very straightforward, with one contract and one arbitration clause, all of this is very straightforward. But what happens if you have a project where you have, for example, 5 or 6 contracts in a suite of documents and a number of milestones, key milestones, spread over several years? Why is this relevant? Well, it's relevant for 2 main reasons. One, jurisdiction is probably the ripest and easiest area for challenge and for a difficult defendant to play games. And secondly, from a case management purposes, say institutional rules can sometimes be quite rigid around procedure. And with a situation, if we take the 5 contract situation, where you have one project with 5 contracts, 5 outstanding debts under each of those contracts, and 5 arbitration agreements per contract, you may, unfortunately, find yourself in a situation where you have to issue a new arbitration request and start a new arbitration for each contract, even though it relates to the one project. And you don't really want to be in that type of situation. If that's the case, or if you think you may end up in such a situation, you might want to look at a separate arbitration agreement covering the whole suite of documents, rather than trying to put a boilerplate clause in every single contract. We move on to the seat of an arbitration. What does seat mean? Well, this is where the arbitration is rooted, which means the local laws of your seat will govern the procedure of your arbitration, and the local courts will have powers to either support or interfere with your arbitration. Your seat can be a neutral third venue. It doesn't have to have any connection with the parties themselves or with the dispute, or even where the assets are based. You don't even have to have your hearing in the seat of the arbitration. In this day and age, and especially with the current climate, virtual hearings are becoming increasingly popular. And you can understand, that being able to pick a neutral third venue is a very valuable feature of arbitration. If just off the top of my head, an example, if you have an American party and a Chinese party on the other side, you can see that London might be a preferable seat rather than America or China. What do you need to look at when you're looking at the seat? Just take a little time when you're looking at an arbitration clause and thinking about the seat to look at the local laws of the seat. Think about the attitudes adopted by local courts. So are they supportive, or are they interfering, or do they have a real hands-off approach? And also think about the scope for challenges to any final award, and if you've got assets in the jurisdiction, any enforcement considerations under national law. I've put up on the slide here, fortunately, we don't really have time to go through today to go through some of these provisions, but please do contact me afterwards, because there are some really important points here. The Arbitration Act 1996 in England and Wales gives powers to the English courts to support the arbitration process. Now, I've split my table, I've given some examples in my table, split them into mandatory provisions and non-mandatory provisions. Mandatory provision, these are powers that the parties cannot exclude by agreement, and non-mandatory provisions, these are powers that parties can agree to exclude. And you'll see here, the English courts are pretty good actually in terms of support and minimal interventionist attitudes. So you'll see non-mandatory provisions, for example, the courts are able to make orders about taking and preserving evidence, but only to the extent the tribunal is unable to deal with it effectively. Just very quickly as a comparison, if you compare to the US, for example, in a recent decision in September 2020, the US Courts of Appeal for the Seventh Circuit declined to give discovery assistance for an arbitration on the basis that a private commercial arbitration panel wasn't a foreign or international tribunal for the purposes of US law. There's a bit of a dispute brewing in the US about this, because the US Courts of Appeal for the Fourth and Sixth Circuits took a very different view. Moving on to ad hoc arbitration and institutional arbitration. Ad hoc arbitration, this is where the parties have not chosen an institution to administer the arbitration. And that means that they independently determine the procedure. It's very flexible. They decide what rules apply and they manage the arbitration. It's not as bad as it sounds, because depending on your local laws, so in England and Wales, you have the Arbitration Act. Many local laws provide a loose structure which parties can follow for the procedure. And there's always, it's a last resort, you've always got the UNCTRAL arbitration rules. What I would say is that if you don't have an institution to administer your arbitration, you'll have to be prepared, either the parties themselves or their legal teams will have to deal with all the administration. So what you save in administration charges, you may be paying in terms of legal fees or time costs. The benefit, of course, with ad hoc is that it's far more flexible. And so if you have a very technical dispute that's slightly different to your normal legal arguments related dispute, it might be a better choice for you. I've put on the slide here major arbitration institutions, and we've picked out some of the more popular or commonly known names. Again, with these institutions, I mean, they're very good. They're very well set up. They all have standardized rules, published fee structures, and they often offer standard boilerplate clauses which you can incorporate into your agreements, which can be very, very helpful. We don't have time today to go through all the differences between the institutions, but I just wanted to pick out some key features to think about. So you have your specialist institutions. On our slide, we've got WIPO and ICSID. You have your international disputes, which is obviously the Hong Kong centres, Singapore and the London and ICC centres. The charging rates can be quite different. So for example, the LCIA will charge you on an hourly basis, and the ICC will charge a percentage of the value of the dispute. And one of the really interesting differences is the level of scrutiny between the different institutions. So for example, the ICC offers an independent scrutiny and approval process by the ICC court to ensure consistency across all of their decisions. We're going to look now at the last factor with the arbitration agreement, which is the tribunal itself. I've put on the slide a number of questions you need to consider. How many arbitrators to be appointed? I recommend odd numbers. Normally you get 1 or 3. Where you have more than one arbitrator, so if you have 3 arbitrators, will you have a chairperson, and how will that chairperson be appointed? Again, I recommend with 3 arbitrators, I do recommend having a chairperson. It just helps with case management issues and dealing with any deadlock problems. How is the chairperson normally appointed? Usually what happens with 3 arbitrators, the parties will decide to each nominate a party arbitrator, a party nominated arbitrator, and then the 2 party nominated arbitrators will decide on the chairperson, either from a list of options supplied by the parties or themselves, through their own discussions. Have a think about whether there are any qualifications that you need your tribunal members to possess. They don't have to be legally qualified. Often they are, but you may want some sort of technical expertise as well. And I've put on the slide the opportunity to nominate. What I would say is that with a single arbitrator, you'll often find that parties will suggest that the institution appoints the arbitrator for them. The reason for that is because by the time you're in a dispute, the relationship between the parties is pretty poor. So trying to get one side to agree to an individual nominated by the other side is generally quite difficult. Parties, the whole choosing an arbitration, appointing an arbitrator is, conjures up a whole load of strategic considerations. Parties will spend hours of legal time and their own time analysing past decisions or trying to find publications to get some sort of insight into an arbitrator's or a potential candidate's view and how they're going to treat a situation. Whilst all of this is very, very important and quite valuable sometimes, especially when you've got a retired judge that you're thinking of appointing as an arbitrator, one factor and one feature which I strongly recommend bearing in mind is to always make sure that if you can, to have an arbitrator who is robust, proactive and pragmatic on your panel, and you will reap the benefits of that decision in the long run, because they will be able to move the process on, and they'll also be able to cut off a lot of the more underhanded strategies that a difficult defendant or claimant even might employ. We're now going to look at the process of arbitration. I'm going to run through this fairly quickly. I've put on here read the rules, because obviously with litigation the rules are extremely important, but the same applies in the arbitration process. If you opt for institutional arbitration, you'll find that the institutional rules are fairly detailed, and there's a certain procedure to follow. I know it seems to be very obvious, but you do not want to be in court at a later stage, having obtained a successful award. You do not want to find yourself in court arguing about the jurisdiction of the arbitration or a potential procedural irregularity. Arbitration is slightly different. Again, the way the process works will depend on your institution, because different institutions operate different rules and the type of dispute that you have. Some, such as the LCIA, have a fairly loose similarity to the litigation process, whereas others, such as investment disputes, are extremely different indeed. I've set out on the slide a list, just the early stages. So normally to kick off an arbitration, you have your request for arbitration or a notice for arbitration. With treaty arbitration, you might have a trigger letter. And this is a formalized version of the letter of claim, effectively. So you have, it's normally a fairly short document. You set out the basics of your claim and then attach your key documentation. It kickstarts the arbitration process, you pay your fee, and then it starts the clock ticking, the respondent to respond. Once you've dealt with the early exchange of details of your claim and the lawyers instructed, you then go through your appointment process. And again, that will be set out either in your arbitration clause or in the rules of the institution. Once your tribunal is convened, and this is where arbitration starts to differ slightly from litigation, so you often have a first procedural hearing, a first hearing, where the tribunal and the parties agree on a procedural order and sets out the timetable for the rest of the case. I find this extremely valuable and a really good step to have to take. Often with the arbitrations I've been involved in, the panel always prefers to actually speak to the parties involved, either via a phone hearing or a virtual hearing, or even in person if that's easier, just so that everybody gets a feel for the other parties involved in the case and for the arbitrator themselves. Then you reach your statements of case. Now this is where it's really quite different to litigation. With, if we take the LCIA rules, for example, with the LCIA rules, you file your statements of case and attach all of the documents that you wish to rely upon. And then you move on, you exchange statements of case with the other side, and then you move on to the next stages of your process. So you have almost a specific disclosure stage, then your witness statements and your expert reports. With other arbitration processes, the ICC or ICSID, you really file a memorial, where you file your statements of case or your memorial, which can be 400 to 500 pages long, and you attach all of the evidence that you're relying on. That means everything, all of the documents, the expert reports, and the witness statements as well. So it's a very, very big filing at a very, very early stage in the process. I'm going to finish off now and pick up some of the pros and cons of arbitration. I really like this slide because it reminds me of law school, when I open my textbook and you have a long list of advantages for arbitration and a very short list of disadvantages. And then I went into practice and realized that actually a lot of these were not strictly correct. So I'll only pick up a few today because I'm conscious of timing. So we'll start with speed, flexibility and cost. The general assumption is that arbitration is quicker, more flexible and cheaper than litigation. And that's not strictly true. The lawyer's answer is it depends. Really depends very, very much on your institution, your type of dispute, the arbitrators you've picked and the parties themselves. There's no doubt that arbitration is flexible. It is far more flexible than litigation, which is, I think, a real benefit and bonus for arbitration. But speed will depend on very much on your panel. And this is what we were talking about earlier, about picking a panel that's pragmatic and proactive, because it will really smooth the way in your arbitration process. By way of an example, I was speaking to an arbitrator contact recently, and their panel had asked the claimant to plead a particular point in a better way and stop wasting everybody else's time. And they took that decision proactively before the respondent had even raised any concerns. And the polar opposite, I once waited 8 months for a party who had fired their lawyers to appoint new lawyers, because we had an absolutely wonderful and lovely arbitrator who was very, very forgiving and very, very understanding. And that, of course, was far more frustrating for our client. Cost, in terms of, people always say that arbitration is cheaper. I'm not convinced. In my experience, it's pretty much on a par with litigation. You've got to remember that with arbitration, there are unexpected costs. So for example, you have to pay, if you have institutional arbitration, you have to pay your administration costs to the institution, you have to pay your arbitrators, and also you have to hire the venue. And remember, with litigation, you don't have to pay the judge, and you don't have to hire the courtroom. With arbitration, there's also quite a lot of front loading of costs, because you have to file your memorial in a particular way. And so most of your fees will be spent, a lot of work needs to be done up front. And so your legal fees will be spent there. So if cost is the only reason for you to pick arbitration, I'm not sure that is sufficient for that choice. Just on fees and costs as well, they do vary. The main institutions publish statistics around their fees every year, and the Global Arbitration Review collates these fees and gives you a comparison. Please do give me a shout after this talk, because I've got some statistics and they're quite interesting to look at. Confidentiality. This is a major feature of the arbitration process. Again, it does depend on your type of dispute and where you are. And for example, with investment treaty arbitrations, they are subject to the intra-trial transparency rules, which mean that limited information about the cases must be published unless the parties in the tribunal agree otherwise. With normal commercial disputes in the other institutions, confidentiality is an important feature, but it does how it's treated does vary. So for example, the LCIA rules have express provisions on confidentiality, whereas the ICC rules do not. Interestingly, Lord Justice Flo recently suggested that there's some Supreme Court and Court of Appeal judges believe that confidentiality will soon be a thing of the past because parties will want to see some consistency across decisions. I'm not convinced, I have to say. I do think confidentiality is very important in the arbitration process. My last point is enforcement. For me, enforcement is the single main decision why I would pick arbitration above litigation for an international commercial dispute. This is because whilst the reciprocal enforcement of judgments arrangements are pretty good for the UK, there are some key states which are not part of our structure. And these are the US, Russia, and China, for example. US, Russia, and China are party to the New York Convention, which means that enforcing an arbitral award in these states will be far easier than looking to enforce a litigation judgment. I'm going to leave it there for today. I hope this has been helpful for you. Appreciate that the speed has been quite quick, but here are my details. Please do contact me if you would like to discuss any of the points I've raised today in more detail. I'm going to pass now to Mark, who's going to take you through mediation.
Thank you, Jenny. Well, very good afternoon, everybody. And as was mentioned earlier by Bonnie and Jenny, I'm going to speak maybe for 6, 7, or maybe even 8 minutes on mediation. I mean, it's important to remember that mediation is another form of alternative dispute resolution. And so arbitration, as Jenny covered there, is one way of resolving matters outside of court proceedings or in a different way. There are other forms of ADR, of course. Just meeting with an opponent qualifies as being a form of ADR. Perhaps the best form of mediation that most people will be familiar with is ACAS, and the body which tries to resolve disputes in industry, often between unions, where parties come together in a consensual way and they try and reach some form of settlement, some form of compromise together. That's particularly useful, of course, where businesses are working, hopefully working together with one another in the future as well. It's something which court proceedings can't resolve, but mediation can give an ability for parties to get together, the directors to talk and perhaps actually preserve business relationships. But quite often it's a consensual process where parties come together because they want to resolve the dispute that's arisen or the issue on a particular contract. But it can be mandatory in certain circumstances. And one way, of course, it's mandatory is in dispute resolution clauses, which many of us will be familiar with. They'll often require the parties go through perhaps an escalation process, directors, CEOs might meet, and there could be some form of mandatory mediation there before court proceedings can be commenced. And indeed, in those situations, parties can obtain a stay to make sure that the process is followed before court proceedings are issued. It can in some circumstances be mandatory, but most of the time it's actually consensual. So who mediates these disputes? Who attends the mediation in addition to the parties? Well, it's going to be a qualified individual, normally provided by one of the main mediation providers, such as ADR Group, Centre for Dispute Resolution. And they'll appoint somebody, or they'll let the parties put forward maybe 3 or 4 CVs so that they can select somebody themselves. If they can't select somebody, then the mediation body will appoint the mediator. They'll often be a solicitor, sometimes a barrister, or maybe even a technical expert as well. But it's very, very different from arbitration in the sense that the final outcome of the mediation process depends on the parties agreeing something. It's not a situation where a decision is imposed, such as with the court or with arbitration, as Jenny was saying. So why mediate? Well, I've given some very good reasons there, of course, which is perhaps expanding the pie, making sure business relationships are preserved, saving on lawyers' fees, of course, and making sure that disputes are resolved promptly. A court case might take anywhere from a year to sometimes multiple years. So it's a good way of resolving a dispute early and freeing up management time as well. The court is very clear that it expects parties to engage in some form of ADR, whether it be meeting, whether it be without prejudice discussions, or whether it's something more formal like mediation. The court has a discretion on costs, and this is really where it bites. This is the stick to make sure that people do attempt some form of ADR when a dispute arises in England. And the court will normally order that the loser pays the winner's costs. And that normally works out at about 60 to 80% of the final legal bill. But the court has a discretion, and this is very, very important, because the court can penalise parties that unreasonably refuse to mediate or even drag their heels in making the mediation arrangements. So there's some pressure there that the court can apply. So the parties and the court are also bound by the overriding objective, which provides that alternative dispute resolution should be considered, and the parties shall act in a way to try and save costs, help the court in the effective resolution of a particular matter. They're reinforced by protocols, and indeed there's a directions questionnaire that goes out to parties requiring a solicitor to confirm that he or she has discussed this with their client. Cost consequences, as I mentioned, the usual order is that the loser will be ordered to pay the winner's cost, but the court can deviate from that, or it can change the amount to be paid by a particular party. There are 4 cases here, which for further reading I would commend to anyone. In all of them, the court has given some useful guidance on some of the changes to the usual rule and the pitfalls for parties that refuse unreasonably to mediate. So some good weapons there to put in correspondence for the solicitors listening today and in-house lawyers as well. So what are the key considerations then? Well, the first one is when to mediate. Is it best left, once we've had disclosure, once witness statements perhaps have even been exchanged, or is it best to get in early? You may get a different view from lots of different advisors, but personally, I'd say the best time is either shortly before you're about to issue proceedings or shortly after statements of case. So what used to be called the writ and particulars of claim have been exchanged with the defence as well. So at that stage, normally you've got a very good idea of what the issues are and what each party is claiming or counterclaiming. But you will get different views on when the best time to mediate might be. Obviously, the mediator will be attending, but the parties need to make sure that the person who goes along or the persons are people who've got authority. And the mediator will check this on the day. It needs to be somebody who has authority to settle the mediation actually on the day of the mediation. The cost can vary depending on the value of the dispute. Most of the organisers of mediation services link it to the value of the dispute. But typically, you're looking at maybe between £2,000 to £4,000 for a day's mediation plus preparation time. That will be the mediator's fee. Normally, the parties will agree that that will be split equally down the middle. So you can see already, that is a reasonably cost-effective way of proceeding compared to court. Location. Sometimes people get hung up on whether it should be at one party's offices or another lawyer's offices. Personally, I take the view it doesn't really matter too much. As long as the setting is right, the facilities are appropriate, and the space between the rooms, it doesn't really matter. But you will find that sometimes there is a little bit of argument over whether mediation might take place. What about the day? What should we be expecting when we attend a mediation and indeed the lead up to the mediation? Well, preparation is important. It's not like a trial where there needs to be skeleton arguments as such, but there should be due preparation. A statement of case is normally sufficient. Depending on the size of the dispute, that might only be 2 or 3 pages. There'll be a bundle, normally agreed as well, but the mediator won't want to spend more than 1, 2, 3, 4 hours reading a set of papers. So it's normally kept to a small bundle. A confidentiality agreement will be signed between the parties and the mediator. And then there'll need to be a particular setup for the mediation to work. And that's normally one large room at the location where all the parties can come together for the opening session, and then breakout rooms for each of the parties and their advisors, separated for obvious reasons. The mediator will invite the parties to make an opening statement. Sometimes the lawyers will say something, but often it will just be the parties. And personally, I always encourage clients, and as a mediator as well, I'm qualified as a mediator of ADR group, and I'll always encourage people to actually, the clients, say something maybe for 5 minutes before the mediation starts, because this could be the first time that they've actually met since the whole issue brewed up. So it's an important opportunity to say one's piece. And then beyond that, as the day progresses, the mediator will shuttle between the two rooms, and gradually the gaps, hopefully, between the parties will narrow. The mediator will start off by trying to understand what the dispute is about, why it's arisen, how can it be solved. But importantly, he or she will also look at whether or not the pie can be widened. So is there a way maybe they could work together and can carry on with a business relationship? Or perhaps there are some things that nobody's thought about where they can bring new issues into play and try and create a win-win situation. And you'll see that's very different to the more, well, the incredibly adversarial position when one's moving through court proceedings and through the trial. It's very much a facilitative, and it's a really a good opportunity for the parties to get together and maybe create some new deal. The parties also encouraged to look at what the best alternative is to settlement as well, which when you factor in legal fees can often bring clarity to the process. And then finally, if the mediation has gone well, then perhaps towards the end of the day, a settlement is reached. It's not uncommon for mediations that do not settle on the day to settle shortly afterwards. And statistics actually show that around 90% of matters referred to mediation do settle. So it's got a wonderfully high success rate. But what about deadlock? How is the deadlock broken? Well, the clients can come face to face without lawyers. The lawyers can perhaps get together, or there could even be sealed bids where the parties put in an envelope what the amount is they would settle at, and perhaps settle in the middle. Or the mediator can be asked to provide a number. Something very rare, but it can happen. These are tools to break the deadlock. So, some concluding thoughts. What are the pros? What are the cons? And what's the future? Well, I've explained how costs are obviously an important factor. Time, management time as well. There's confidentiality, which should never be underestimated. But what about the cons? Well, you are restricted, of course, in the build-up to the mediation. You can't, it wouldn't be the same if you needed perhaps injunctive relief. Often, particularly in IP disputes, one can't wait for there to be a resolution. You need to move quickly to court. So that's something. There's some disruption time, obviously, in attending a mediation. But compared to court disputes, it's minor. So I'd say that the pros far outweigh the cons. As I say, the success rate tells a very compelling story. In terms of the future, well, as this webinar shows, we're conducting business and work in a very different way, and mediations are no different. Most mediations now are taking place virtually, and they've got a high success rate as well. The success figures are very, very similar to those of face-to-face mediations. There's been some talk about whether or not mediation might become compulsory in England and Wales in the future, but that is just talk, and it's very, very unlikely that the court will ever change the current position, which is purely one of encouragement. So thank you for listening to that very swift run-through mediation. I hope that that was of use, and I'll hand over now to Bonnie for questions.
Thank you, Mark, and thank you, Jenny. And we'll now be taking questions. So please use the Q&A button on your Zoom to submit your questions, and our speaker will try to answer them live for you. And I can see that there are a few questions here. First, we have Justin asking for Jenny. You mentioned room hire costs for arbitration. To what extent can arbitration be carried out online, particularly in the current environment? Jenny, would you like to answer that?
Of course. Absolutely. Virtual hearings have, in the last 6 months, become, well, the norm, really. And what's been quite interesting is that the LCIA issued a set of new rules. They came into force at the beginning of October this year, and the LCIA have amended the wording of the rules to expressly allow for virtual hearings, and recognizing that that might be the norm going forward. Listening to a recent commercial court seminar, the industry seems to be split. The profession seems to be split on the whether in-person final hearings should still go ahead. And I think right now a lot of judges, retired judges who are arbitrators, take the view that actually in-person, face-to-face is still very valuable from a final hearing perspective. Although there may be suggestion of perhaps having some hybrid hearings going forward, so where you only have counsel and the arbitrators and the witness in the room, and everybody else attends remotely. So watch this space, I think.
Perfect, thank you, Jenny. And Naeem also asked, what shall be taken into consideration when using mediation that ends with written agreement between companies in 2 different countries? Mark, I believe this question is for you.
Yes, well, one of the beauties of mediation is, of course, if it's successful at the end, it should find its way into a written contract on that day, a settlement agreement. Now, of course, it depends on whether or not litigation has already started, because if litigation has started, then there'll be court proceedings that need to be dealt with as part of that mediation agreement. So you would typically have a mediation agreement and then attached to it a court order, which would bring the litigation to an end. So that court order, would be enforceable in different jurisdictions. If it was a monetary order, then that would be relatively straightforward. Most jurisdictions have treaties with the United Kingdom where we can enforce judgments abroad. So, for example, I've enforced judgments in New York before, taking over proceedings from London. And of course, in Europe, it's relatively straightforward as well. With some jurisdictions, it's going to be harder, but for 99% of business disputes, that written contract at the mediation will be enforceable in other jurisdictions.
Perfect. I think there's another question for you, Mark. If you're in a mediation or litigation and the matter does not settle, what happens with the cost?
With the cost of the mediation? Yeah, it's a good question. In most cases, the parties will agree what should happen to the mediation costs, because there's been some debate about whether or not they should be wrapped up in the general costs. If you remember at the beginning of the talk, I explained how the winner can normally expect in order that the loser pay their costs, and that would be the time of the lawyers, etc., and the disbursement of the mediator's fees. I would suggest that unless the parties actually agree that they want those costs of the mediation to be wrapped up in the general bag, then they should not be recovered at the end of the case. But again, the way to deal with that is to make sure that it's discussed and agreed between the parties before attending.
Perfect. And I think there is a question for Jenny. How long would a normal arbitration process be?
With all these things, I'm going to give a lawyer's answer, which is it depends. Depends on your type of dispute that you're dealing with and complexity, and also on the parties and the attitude of your arbitrators. I mean, with a general commercial arbitration, the truth is, I would expect a typical complex arbitration to take a very similar time as to the court process. If you have, for example, investment, everyone hears horror stories about investment treaty arbitrations, which last for 2-3 years minimum, if not longer than that. But I would look to deal with a commercial arbitration in probably, I don't know, a year, 18 months, if that. I think if the parties work very hard, they could certainly deal with it at a much quicker pace, perhaps maybe aspiring to be something along the lines of the shorter trials process, getting things done within a year, for sure, if you've got a straightforward commercial arbitration.
Perfect. Thank you, Jenny. And I think we have another question that came in from Naeem saying, in circumstances in which the dispute is between two companies and one files on LCIA, the government of another, the question is that what would be the role of the other company, the company of which the government was filed against on LCIA? I believe this is for Jenny, or?
Yeah. Yeah. So with this one, with the LCIA arbitration, and normally with a government arbitration, I think we'd be looking at a treaty arbitration there, Naeem. It would certainly, we would have to look at the institution that they pick, which would normally not be the LCIA. So the LCIA would typically look only at commercial disputes. Perhaps it's something that I'll pick up with you on a separate call, and we can pick up after.
Thank you, Jenny. I think we have one final question left, which is, what would the typical cost of arbitration be?
With the costs of arbitration, very much on par with litigation, and of course it varies. I'm going to be very annoying and give another lawyer's answer here, because it varies depending on the number of arbitrators you have. So if you have one arbitrator versus 3 arbitrators, and also whether expert evidence is involved, I would certainly, as I said earlier, I would certainly expect your arbitration costs to be in the same region as your litigation costs. And yeah, I would, if cost is the only reason why you would pick arbitration over litigation, I wouldn't, for me, it wouldn't be a deciding factor, and you have to budget accordingly.
Thank you, Jenny, and thank you,
What
Mark.
I would say, sorry, Bonnie, what I would say is it's always worth looking at, and I can share the link, I can give Bonnie the link to share when she sends out the slides, but the Global Arbitration Review prepares a really, really helpful table which compares the different institutions. I think they compare 5 or 6 institutions, and they look at 1 million, 5 million, 10 million, I think $100 million claims. And they also compare 1 arbitrator and 3 arbitrator as well. So you'll have a table where you can actually look at your different institutions and get a real feel for what the costs were last year. Obviously 2020 figures haven't been published yet, but we've got 2018 and I think they have 2019 figures as well. So it's quite a useful table to look at.
Thank you, Jenny, and thank you, Mark. And thank you everyone for participating in the webinar. And if you have any questions or any issues of arbitration and mediation that your company is facing and you would like to discuss with Mark or Jenny, you can email them directly, and the email addresses can be found on the agenda or on our website. We'll also be sending out the PowerPoint slides and a feedback form for you to fill in. And it will be great if you can just spend 2 minutes of your time to fill those in so we can tailor make these webinars for you in the future. And if you would like to rewatch this webinar or share it with your colleagues, this webinar will be made available on demand on YouTube shortly. So make sure you do follow us on LinkedIn, and that's for you to get updates about it and other future webinar invitations. And thank you so much for participating, and we hope to see you again soon in our future webinar. Thank you.